Twitter. I'm just telling you that I want to explain. I've been doing a little things on writing. I hope that this is mostly for the rewatch crew because this is absolutely impromptu. The wife is walking. We've got to go to church at 11, so I just wanted to stop by and capture this moment for you before next week hits. And again, and I've been thinking, I wanted to share a little more about academic writing. This is what I think about in the shower. And I said the public defender's office should pay me for taking showers, because here it is Sunday morning, taking a shower. The wife's walking her walk after walking the dog. And we have church in 30 minutes. We got to leave. But in the shower, I have little sticky notes, as you know, at work, and see they're wet and my hair is wet. And in those sticky notes, I've been thinking about this for quite a while. And I also been talking about my opinions regarding the circumstantial evidence rule and the Florida Supreme Court and Justice Labarga and his excellent dissent in the case Bush v. State out of Florida, Bush v. State, which overruled State v. Law involving the circumstantial evidence rule applying to cases that basically the circumstantial evidence rule is cases that are completely circumstantial, that if there's a reasonable hypothesis of innocence, that it should be not guilty, right? There should be a JOA granted. So I've been writing, and I've also got this idea because if you saw back, I have a Rumble stream on the beyond a reasonable doubt standard and the fact that we're getting away from it. And it's a very confusing standard. All right. Now I did a whole live stream on that also. So I'm just going to show you how these things develop and when you need to capture them. So I wrote in the shower these little notes, and I'm going to share with you the writing process in academic writing and creativity. So I'm going to start with a blank piece of paper like we do and present. Let's see, share screen. Okay, you see this? All right, so here I'm just first I've got these little stickies, which are actually in shower notes. So I'm going to just write it out straight, what I wrote in the shower. And it was just enough to remind you what I'm thinking about in the logical concept. So first is, in order to teach a concept, this is from my educational background, you need a definition and one or two examples at a minimum. Okay, so that's minimum. Okay, so that's the first thing. So we've got the circumstantial evidence rule, and reasonable hypothesis of innocence, hypo. Okay, and my spelling is terrible. See how I just get it down as quick as I can, and I'll fix it back here. Reasonable hypothesis of innocence, right? And we've got now okay, I'm going to emphasize hypothesis because I'm also got some alternative words here, which that's a legalistic and high level term. So I'm going to put on there theory, scenario, possibility. Okay, and this is just the way the creative mind thinks. Whoops, let me do that. So I'm going to bold this because that is going where I want to go. And then I've got, okay, now to my next sticky. So I'm going to throw that one out. I've got this one captured. So now we're going to go reasonable suspicion standard. Okay, now I might have these in reverse order. Suspicion standard for stop of citizen. Okay, and so what I'm going to say is this needs to relate to beyond and the exclusion of reasonable doubt, which I call BIRD, beyond exclusion of very reasonable doubt. And then I'm going to further riff on this, if it is enough to justify detainment, then it is a reasonable doubt by definition. Okay, well, what is the definition of reasonable doubt? What is definition of reasonable doubt? That's kind of what we're looking for, right? Okay, so I got that sticky in. Okay, now we've got Bush v. State overrules State v. Law, doing away with circumstantial evidence rule in Florida. See LaBarga dissent. See, now see how bad my spelling is, and the reason is because I'm really a bad typist. But okay, we've got that. I'm going to put, I know what I want here, special jury instruction. This is the basis. What I'm working on is refining an academic article. Throw out that sticky. So I'm going to here's a possibility for a special jury instruction. In this case, the evidence is entirely circumstantial. Therefore, if you find that the facts support a reasonable hypo of innocence, then you should find the defendant not guilty. If, on the other hand, you find the hypo of innocence unreasonable, then you should, and let's just leave it there, okay? So I'm going to save this as over here in my work docs. Well, maybe I'll put it in my streaming docs. All right, so we've got this. So this is what I wrote in the shower. Now, these are cues for me to further develop this idea. What I'm working on is a law review article on the reasonable doubt by definition. I'm going to show you this also because, okay, we share, present. Okay, this law review article, which is excellent, done by Judge Lawrence Johnson from 1998, January 98. You can look this up. I did a whole live stream on this about how bad Florida's beyond a reasonable doubt standard or definition is, the jury instruction. So what I'm working on is a jury, an alternative jury instruction for Florida. And I think that, let's see here. Did you see that? Yeah. So you need to look at that. And then state v. laws of definition, beyond the definition. What is the definition of overruled? So let's talk a little bit more. So you see this special jury instruction? I think this is pretty cool. So if you've got a circumstance, okay, what Bush v. State says, I think, and I need to go back and review these to make sure that I'm reading it correctly. Bush v. State says that the circumstantial evidence rule is not an appellate standard, all right? And so they're doing away with that as appellate review. Now, I don't agree with that, but let's assume that's what it says. And I need to go back and reread it based on my new thought and new view of this. Assuming it's not an appellate standard, I think does that mean that the common law is completely overridden? Does the circumstantial evidence rule exist in Florida courtrooms at all? So for example, and I think it does. And the reason is because it echoes the beyond the it is by definition, if you have a reasonable hypothesis of innocence in a circumstantial case, then that is by definition a reasonable doubt, and you must find the defendant not guilty. So through the definition of beyond a reasonable doubt, I think the circumstantial evidence rule should survive and does survive. But it's a jury question, perhaps, or it's a judge question at JONV. So judge question at JNOV, in which the judges have to apply another juror. They have to be an additional juror and weigh the evidence. So again, if the jury finds him guilty, you then put it to the judge. You have to operate as another juror, and there is a reasonable hypothesis of innocence in a circumstantial evidence case. Again, the judge must grant JOA, and I think that is appealable, should be appealable, because that is something that is, if, whether it's a circumstantial evidence case or not, maybe that's an issue of law. But whether or not there's a reasonable hypothesis of innocence, that may be a factual question for the jury or a judge at a JNAV. And I think it could be looked at from an appellate standpoint. So what I'm trying to do is, first of all, maybe craft a special instruction for our trial teams, something like this. In this case, the evidence is entirely circumstantial. Therefore, if you find the facts support a reasonable hypothesis of innocence, and I'm thinking I'll change this hypothesis to scenario, theory, possibility, something like that, because hypothesis gets confusing, then you should find the defendant not guilty. If, on the other hand, so maybe we could put in here definition of hypothesis, right? In definition of hypothesis. Then you find not guilty. If, on the other hand, you find the hypothesis is unreasonable, then you should do what? I mean, you don't want it that you say, continue to consider the case, weigh the other factors in the case, something like that, to determine the issue of guilt beyond a reasonable doubt. Okay, so I think that the definition, by its very nature, the definition of reasonable doubt implies the circumstantial evidence rule. And I very much disagree with Bush v. State. I'm going to be arguing, but in order to fully challenge Bush v. State and the doing away with the circumstantial evidence rule, I think I need to fully understand the groundwork of it. Now, this could also be accommodated through legislative action or procedural. Is the beyond a reasonable doubt standard? I would like to see a better beyond a reasonable doubt standard. And in that case, and this is where I'm also going here, in order to teach a concept, you need a definition of one or two examples a minute. The beyond a reasonable doubt standard in Florida does not do that right now. It's horrible. It's a horrible, confusing standard. And I think prosecutors love that because it weakens the rule. So what I'm saying is we need to compare what is a beyond a reasonable doubt. Well, a reasonable doubt should be equated to a reasonable suspicion standard for the stop of a citizen by police. Okay, so in order for a police to interact with you or to detain you, which is violate your constitutional right to walk away, if they have a reasonable suspicion, okay, then they can detain you temporarily, right? Now, a reasonable suspicion for detaining you temporarily. Well, if they have a reasonable suspicion of criminal activity, if that's our standard for violating somebody's rights and stopping them without their consent, then it seems to me then that is equatable to the other end of the spectrum. So a reasonable doubt would be, to me, if you have a reasonable suspicion that criminal activity is not afoot. So you have a reasonable suspicion that criminal activity is not afoot, or that the defendant did not do it, then that is a reasonable doubt, and you must find the defendant not guilty, right? Does that make sense? So if it's good enough for the state, what's good for the state is good for the gander, right? If the state says we can stop you and violate your rights based on a reasonable suspicion, see, it still contains that reasonable word. And reasonable suspicion, I suspect, and I've got to do a lot more research. This is part of my game. But reasonable suspicion for criminal stops is something that is well litigated in criminal courts. The reasonable doubt standard is not. And the reasonable doubt standard is quite difficult. You're saying you're joking with me, Dr. D. I'm streaming a lot of cramming it in because next week I got another death penalty case coming in, and I took a nice long break over the Christmas holidays. I'm cramming it in, and I wanted to share whatever I could with you. If the wife comes in, then and I'm off. And this is completely impromptu. It's going to be mostly replay crew, I expect. But I'm trying to get you. I'm trying to do some stuff here to get some ideas. So I've been working on this reasonable doubt standard, and what I would suspect is that I would add a chapter to ideas and answers. Once I finish this law review article, I'll add a chapter to ideas and answers law. I also need to edit the chapter on concealed carry in a car article because it's outdated given the change of law in Florida, although the concept is still good in other states. I need to update that. So this is why I'm doing it. But I wanted to share with you some of my thoughts here on beyond a reasonable doubt because I got on railing on how we don't, we no longer believe in the reasonable doubt standard, beyond a reasonable doubt, because we have judges who sit up in their ivory towers and ponder how they can whittle away. Because boy, isn't it terrible that some judge might grant a JONAV motion or a JOA motion because somebody has a reasonable hypothesis of innocence in a circumstantial evidence case. We can't have that. So we're going to throw out the circumstantial evidence rule as an appellate concept. And because we don't want to let one person get away with anything. All right. I'm against that. So we're throwing it out. So we need to redefine, we need to be clear and understand the reasonable doubt standard, its source, where it's going, and how it's defined. And then I'm looking to create a article in a tool for trial attorneys to use to ask for a better standard, to ask for a special jury instruction in these cases, and to establish to the unconvinced why I'm right and why the reasonable doubt standard should be fully enforced and strongly enforced. So this is why, and I just wanted to share with you. See, okay, so here's what I wrote these things down. I've been thinking about this for a lot, and I actually have quite a bit of this article kind of written and drafted, but I hadn't put together the circumstantial evidence rule and the beyond a reasonable doubt standard quite in the way that I did in the shower just now. And so I thought I would share with you. Now, what I'm going to do is take this document, I'm going to email it to myself at work, and then integrate that email into the greater article, which I have structured, and make sure. And I really need, given that insight of could we do a special instruction and the things that we just discussed there, how can we do it? Because I think that special instruction is pretty cool. But is it correct? Is it a correct statement, or should it be a correct statement of law? I think it is. So this is all. I just wanted to mention to you now, if you want to get ideas and answers in law, we have, oops, I'm sorry. These are sold. So they're running further down. I've got the hardcover ideas and answers in law, which you can support my work. If I sell out on these, then you'll put pressure. Well, I've got a number of the soft covers. So if you buy me out, then you're going to put pressure on me to give you the third edition. This is the second definitive edition, I must say. This is the edition you want. Hardcovers available at stevegosney.com, and hardcover prepares available, and they're all signed and numbered, 3 of 9. Please support my work. I need the help because this book publishing, my objective is to break even. So that's what I'm doing. So I've got to go to church. I hope you go to church today. And let me see, I've also got, see all these notes, and this one here is, oh yeah, you see so I put here, edit Stand Your Ground Gun in article for Ideas and Answers 3rd edition. You see there? And then the bottom there, this is how I write in the shower. Reasonable doubt instructions equals circumstantial evidence rule. See, that was the inspiration. So to me, complaining about circumstantial evidence rule change in Bush v. State and overruling State v. Law and doing away with circumstantial evidence rule, that really bothers me. And why does it bother me? And this is the inspiration for a lot of my law review articles in Ideas and Answers, is it's like, that's wrong. Something's wrong with this. Something's wrong with it. And I don't know why. All right, I got to go. That was the life. See you later.